Hi, everyone. My name is Leena Yousefi. I'm a family lawyer, CEO, and founder of YLaw Group, a family law firm in the beautiful British Columbia. Today, I wanted to speak to you about reports which are often called Section 211 reports, custody and access report, or parenting time reports. These are reports which are very common as you're going through a custody dispute through the courts. And our courts are usually the BC Supreme Court and the Provincial Court. So I wanted to go through what they are, how to get them, how much they cost, and all the good stuff. The first thing is, what are they? So if you and the other parent can't agree on a proper parenting time arrangement for your child and you're in a dispute, you can ask a judge to order these reports. And what these reports are is basically a psychologist, social worker, or a family justice counselor, an objective, impartial, and trained individual coming to your homes, interviewing you and the other parent, sometimes the children, calling your references and looking at the background of litigation and determining what is in the best interest of your children and what is the best parenting schedule that should be implemented in your case. These reports are ordered by the court and they should be done by someone who's impartial and experienced in this field. How much are these reports? They can range anywhere from $8,000 to $20,000 or $25,000. They're very expensive, so you should only go with these reports if you absolutely need them. I always tell my clients that the best people to make a decision regarding the future of their children is themselves by, cooperating and compromising, not paying someone, 20 grand to determine what should happen to your children. I know sometimes it's not possible to cooperate with the other parent, but these reports should be the very, very last resort. How to get these reports is, I've gone through them but specifically at the BC Supreme Court, you basically have to set down a notice of application and an accompanying affidavit, book a court hearing and ask the judge to order them. At the provincial court, you have to file a notice of motion and an affidavit to get them. All of this information is actually explained in our blog in detail. So, if this is going over your head, you can always go to our blog and look at the specific procedures and links to the forms that I'm speaking of. How long does it take to do these reports? If you do them privately, meaning that you get an order and you go to a trained psychologist, they can take anywhere from 2 months to a year and a half, depending on how busy the psychologist is. There are very prominent ones that have very long waiting lists, such as Dr. Corpatch and Dr. England, and there are some that have lower waiting lists. So you have to kind of go through which ones are most suitable and how long it takes. I've included the names and contact information of these reporters again in our blog. The other way to get reports, and that's a free way of getting them, is to get a judge to order them to be done through the government, through a family justice counselor. These reports are free. However, you and the other parent need to have a lower income. They have, I don't know exactly what the income level is, but you need to be on the low income level. And they can take a long time, sometimes a year and a half to 2 years. And the other risk is that they're done by a family justice counselor, not a psychologist. So it can be a bit more risky. What happens when the report comes out? So a copy of the report is given to you and the other parent, and a copy is filed with the courts. And what happens is that this report comes in front of a judge. The judge reviews this report, and the judges often say that these reports are the eyes and ears of judges, because the judges aren't able to see your family dynamics, interview your children, and so forth. So judges tend to follow these reports unless you can concretely challenge these reports. So what happens is, once you get these reports, there might be a high chance of settling your case, because you realize that you're facing an uphill battle if you don't agree with the reports. Or if the reporter gets it wrong, then you have to cross-examine the reporter or the psychologist at trial. So you have to ask them to come to trial, and you need to ask them questions to show the judge that they made a mistake. So sometimes they make mistakes that are super obvious, like you give a report card of your child to them, which happened on one of my cases. And in the reports, they had used the report card of a different child, like completely unrelated. And that child wasn't doing well at school. So then they were saying, well, this child isn't doing well at school with my client, therefore custody needs to change. So of course, you know, in those situations, you can challenge them and the report won't mean anything to the judge anymore because they made a major mistake. Sometimes the mistakes are more minor. And so it's really important to, very, very important to speak to a family lawyer to see, do you need these reports? Is the reporter the right person? And if the report has come out, is it worth your time to challenge them? So, you know, before spending all the money, it's good to talk to a lawyer and see, you know, what way you have to go through them. And the last thing that I wanted to talk about is that there's 3 types of Section 211 report. The first type that I've been speaking of is the comprehensive type that I went through, you know, interviewing children, looking at report cards, looking at references. There's a second type called view of the child's report, which usually applies to children who are over the age of 12. And in these situations, the psychologist goes and speaks to these children and basically relays their views and wishes to the judge. That's why the children need to be a little bit older. These reports can range anywhere from $800 to $3,000. And sometimes the reporter can write an opinion on whether they thought, when the child is relaying his or her wishes, are they being trained to, or are these feelings genuine? So, because in a lot of cases, children are alienated. So just relaying their wishes might be superficial. You might have to tap a little bit below the surface. And so in views of the child report and the extensive Section 211 reports, you do get an opinion on whether there's alienation. And then there's the third report, which is the cheapest and the quickest. And these reports can also be done by lawyers. And these are called Hear the Child reports. And they're strictly basically transcribing a child speaking to a lawyer and saying what his or her wishes are. So there's no analysis. It's just, hi, judge, I spoke to this child and here's what he wanted to say to you. And there's no more analysis beyond that. And these reports usually happen with children who are, you know, over the age of 12, more commonly over the age of 16, because at that point, I guess whether they're being alienated or not, it doesn't matter. Their wishes are their wishes, and the judge will mostly follow their wishes at that age. So that is a summary of what these reports are. Again, if you have any more questions or comments, please call us at 604-974-9529 or email us at info@ylaw.ca. My name is Leena Yousefi, and I'm a family lawyer at YLaw Group. Thank you.